I don't know. Okay, cool. I'm recording this anyways. I will share it with the. Oh, Anubha is also here. Hi, Anubha. Uh, so I'm starting. I will be talking about Canadian constitutional law. We are not going to be solving a paper today because there is only one sample paper available from NCA. I don't want to solve it for you now. I want you to go through your studies, and then once you're done with your thing, that is when you should be looking at your IRACs, and then perhaps IRACs with your knowledge that you've gained, and then your sample paper right before, maybe a week before your the exam starts, you should be solving it. But for now, let's talk about what to expect in the constitutional law paper. Unlike other papers, constitutional law paper has multiple questions. People who have written admin law, people who have written foundations law can expect maybe only a single question in the entire paper. Like, I don't know who has written admin law in this group, but I had one question of admin law, and perhaps, I don't know, maybe anyone else can chime in how many questions they got. So those are very different ball games altogether, but it's not difficult. It's easy if you approach it right. Constitutional law has multiple kinds of questions. There can be 5 markers, about 6 questions to 5 questions, which are just, who's the head of who's the head of the state in Canada, or it could be what is the notwithstanding clause, does, whatever. These will be five markers questions, which are very simply solvable, and that is the reason why I always ask all of you all to keep flagging your notes when you're studying and highlighting them, so when a question comes in the exam, you know exactly what topic it will be in, and you can jump to it and simply answer, and not spend more than 5 minutes on your 5 markers. Your intention in the paper should not only be answering the exams correctly, but they should be not wasting time at any point of time. If you're spending more than 5 minutes on a question, skip it, move to the next question, finish it all, then come back and finish your 5 markers, because there are cases, there are students, and there are colleagues that I have previously worked with, who have made this error, and they spend half an hour on 5 markers and then regret it later. So 2 to 3 minutes per 5 marker is more than sufficient, and then you jump on to the bigger questions. Having said that, you can expect the first kind of question you can expect is a charter question, which is effectively the biggest chunk of your question paper. And the charter question would be a fictitious situation. This question will have a huge amount of facts, maybe 2 paragraphs, 3 paragraphs, or could be more. And the fun part here is that 80% of it is completely a distraction tactic from the NCA for you. They will be giving you so many facts, you'll start reading it, and then you'll by the end, and you will realize, okay, the rest of the question is completely irrelevant. I don't even need to get into it. I just need to focus on this few 4 lines, and then start working on my answer. So a constitutional law paper is starts with a charter question, and effectively the summary, the need of this question is that there would be a body. It would be public or private, or it will be a private body being working through a public action or public power, and under a public power, and there will be a situation where they have breached your charter right, one of the charter right, or maybe more than one of charter rights. So they will also give you a situation where, okay, now that your charter right is breached, which was granted, guaranteed by the charter, which should not be breached, how do you go about it, and what will be the likely situation, what will the court do? And in this situation, then comes the Oakes test and justification of section 1, and then if it's justified, then what proportionally is it, what is the proportionality test, and all that stuff. Now, if you have not studied constitutional law, don't worry about it. If you are studying, also don't worry about it, because it's all mentioned in the IRACs. So and I guess Vinay has opened it already. Neha is also here. Neha, we are discussing the constitutional law, answer structures and how to go about it. So if you have your notes in front of you, can you please just jump to the 141 page of the notes, which is the first IRAC, so that when I'm talking through, you have more sense of what I'm talking through. And for others who don't have my notes, don't worry about it. I will be talking a little briefly so that you know what I'm talking about. I'll explain everything. And you can get my notes for the IRACs, or you can prepare your own IRACs when you study from whatever source you are studying. So yeah, that's about it. Okay, so now once the proportionality test in the IRAC is done, that we know, okay, the charter right has been breached, and I'll repeat it from the starting. Okay, I'm just going through the brief first. Then you apply, because you've already discussed your facts, which is the issue. Then you discuss your applications, which is the rules, which is the charter rights, which right has been breached, and if it has been breached, then how is it justified? Is it justified? And if it's justified under proportionality test, what is the proportion under which it should be justified or not? Is it, is the justification too big, or is the justification fine, it's balanced, or whatever? All that language is written in the IRACs. Then we do the application. Then we say, we do the analysis. We say, this was the rule, these are the facts, as per my understanding, this is the situation. And then you conclude it by your own understanding. And there is no right or wrong answer in any of the exams here, because you have to also look at from that point of view, that even a court of appeal judge can pass a wrong decision, right? And which can be overturned by a Supreme Court. So as long as you're giving a reasoning and applying your own legal mind, and saying that this, I think, is not justified, or is justified, or maybe give degrees to it, highly likely, unlikely, most likely, those kind of degrees to your justification, you should be fine, because the examiner will look at from how you have applied your legal mind. And there is where they will give you marks. They will not say, oh, this part there was a wrong, it should not have been justified, why has this person justified it? They will not be marking you like that. So there is no right or wrong answer. The thing they are looking is the legal mind application from starting till the end. Now let's talk about this answer structure from starting till the end. Okay, so the first step of any charter question is to see if the charter applies to the body. Now, for the people who have not started studying, please don't worry about it. This is like I explained just a little briefly. In Canada, when a charter right is breached by a public body in its public power, people can go and claim a charter breach. And when it's a private body, like for example, it's an issue between two friends or maybe your employer, then you don't have a charter right, then you cannot claim it. But there are some exceptions which are also written in the IRACs. Anyway, so the first step is to see the charter applies to the parliament, to the government, to the legislature and the government of each province, municipalities, courts, common law. These are the places where the charter applies. So when you start out and when you're preparing, if again I repeat myself, if you're preparing through my notes, the IRACs are already provided, you don't have to go through this pain. But if you are doing your self studies through the main books, through I don't know somebody else's notes or whatever, in that situation you need to prepare this thing, and you need to write things like whether the charter applies to the body, and then you have to write the rule, section 32, the charter applies to the parliament, and you have to write the whole section down to explain the rule. And then you further mention that the charter also applies to municipalities and their actions, the relevant case law. Then you also write the charter also applies to courts as per Ray 1987 and British Columbia Court of Employees Union versus British Columbia 1988, unless it's a matter of purely private dispute. And then you also write under common law, the charter only applies in cases where there is a rule of statute under common law. See dolphin delivery. Now, these are the things that you may or may not write. If you feel like the question is talking about municipalities, then you have to write the part till municipalities. If you feel like the question is talking about only common law powers, then you have to write the relevant common law line. So you have to use your brain a little bit in the paper and see the IRAC and see, okay, out of these 20 lines, I can let go of these 4 lines because they are completely relevant to what the question is asking. I don't want to also give extra information that the examiner is not seeking from me. So you pick those certain part of the IRACs and you copy paste. Of course, you cannot copy paste because you'll be studying from physical notes, writing from physical notes during the paper, but effectively you type it down. Like you clearly write down the rule as it is. Like the first step, this is it. Now, sorry, I forgot. Before this first step, you have to, of course, analyze the issue because you're doing IRAC. So first is the issue from the question. You write, paraphrase the question, the relevant part of the question, that XYZ is seeking a charter remedy because that person feels that their charter right has been breached by so and so body, and therefore the person has reached before the court. The issue beforehand is that can the person's charter right be justified by section 1 or not? So this is the kind of issue that you will bring out from the question, and then you start with the step one. Now once you have written down the step one, or maybe if it's a private body, then there are multiple exceptions, such as substantial degree of government control. Like for example, I'm making vaccines, and but I'm not doing it completely privately. Like for example, AstraZeneca is a company that is a private body, but they when they are preparing vaccines for government, they are in a substantial control under the government of the government. So in that case, will their actions be subject to charter rights? I don't know. That is something that might as well come as a question. So then in that case, you have to write down that substantial degree of government control under Douglas Quantlen, sorry, I don't know how to pronounce his name right, Quantlen faculty, ASSN versus Douglas College. Now you've written the rule, you've given the rule to the examiner saying that I know this, that if there is a substantial degree of control of the government, this is how the charter right will apply. This, because of this case law, the charter right will apply. You've given the rule, you've got your points. Again, another caveat here could be implementing a specific government policy or program. If the government has hired somebody to, let's say, mine a place, and they are government contractors, then charter rights will apply. Or if there's an indirect impact of charter through human rights code, then also charter rights can apply. So these are some things that you can write in the first step of your analysis. And then you move on to the next step, which is now you talk about, once you've established that, okay, the actions of this body are subject to charter rights, then you move on to the next step, which is, are there any constitutional rights being infringed? Now, again, you go back to the question. You see, okay, let's say they were talking about, freedom of conscience and religion. Let's talk about section 2A. Let's start with there only. So once you finish with step one, then you move on to step two. And this is, again, the people who are looking at IRACs, you know what exactly I'm reading through, because it's all written down. Then you write, you conclude your step one and say, the charter rights apply on this person because the actions were by X and XYZ body, and under so and so case law, or under so and so rule or section, whatever the case may be, the charter rights apply. And then you move to the next question and you look at, okay, which constitutional rights are being infringed. Then you write, the onus is on the applicant or claimant to demonstrate that an infringement has occurred. What is the purpose of the law in action? You write in the bracket Big M Drug Mart, and you mention the purpose of this law was to, and then you explain that. And then if you jump to the next slide, Vinay and Neha, you will see next page, you will see the rules are being explained as well. So in a combination of the page 142 and 143, you have to write the rule down. You have to write, okay, as per section 2, everyone has the following fundamental freedom, and 2A says freedom of conscience and religion. And then you go down to 2A and say, as per this rule, they have a sincere, they are sincere in their beliefs. Beliefs could be personal or private. You write the relevant case law, which is written here in the bracket. Then you write, must show that they have a practice belief, have a nexus. So again, IRACs are prepared in a manner where you don't have to even open the notes for most of your exam. Your notes are there to help you in case something comes out of the IRACs, because of course we cannot foresee every question, every possible situation that the NCA will throw at us, but we can prepare for the major chunk of answers. Like for example, we know if it's a charter question, it will be breach of charter rights only. So all the charter rights are covered. Now if they say they come up with something super creative, then there may be a situation where you want to have to go to the notes as well to find the right solution, but that's highly unlikely. But again, so you have your section 2, all the subsections A to D, then section 7, 8, 10, 10A, B, C, then 15.1 and 15.2, which are the main charter breaches questions that may come. It's covering conscience, religion, thought, expression, peaceful assembly, association, life, liberty, security. This section is super important. Then we have unreasonable search and seizure, and so on and so forth, like race, equality, benefits, etc., etc. There are so many of them. Now once you write these things down, or whatever the relevant, you don't have to write the entire section 2 to 15 in the paper. If the paper is asking section 2A, just 2A. If the section is asking maybe section 15, then you talk about section 15. You do a combination of 15 and the thing which is mentioned in the next page, which is explanation of the rule. You write them together. You can write it as it is, or you can of course be creative with your own legal command and language, which I always encourage people to do. And do that before the paper. See what you want to write, understand and absorb the IRACs. So during the paper, it should not surprise you that what does this line mean? Should I write it? Should I not write it? You should know the entire IRACs by heart. Not, of course, you don't have to remember it. Like back in India, we have to write papers by remembering stuff. Here we don't. We just need to mark them properly so it's in front of us. All right. Once you have written down the rule, is when you move on to the next step, which is justification. Now, for those who will study or who have studied already and who know about Oakes test, Oakes was a case law from 1986 that established most critical, most important, common law rule where justification of, a charter breach is I don't know. It's like, you go to the court, you ask the court that, hey, my charter right has been breached, and as per the rules and guidelines laid down under Oakes, they will see and tell you if the charter right which has been breached can be justified or is it unjustifiable. So it's not like your charter rights are completely nobody can come and breach them. Your charter rights can be breached as long as there is a justification. So for example, you are saying you're claiming freedom of expression, but in your speech you have a hate speech, you are going ahead and I don't know, defaming a particular race, or you are trying to incite violence against a race. So the government can come and cancel your speeches or arrest you even. And in that case, you will go ahead and claim a breach of section 7, which is life, liberty, security, and then you'll claim a breach of section 15, which is it's 15, right? Discrimination against so and so race. No, actually not. It's not. Then you'll claim section 7 and you'll claim section 2B. In that case, you will go to the court. You will say my charter rights have been breached, and then the government will come and say, no, I can justify my actions. And then they will explain their justification, that why we did it and what were the reasons we did it. And the court can in that situation say, okay, the government did breach your charter rights. That's fine. That's established. But under section 1, they can be, the charter breach is reasonably justified. And so there is no damage or claim that you can, a remedy that you can see. So this is the kind of a situation that can be asked, one hypothetical situation. Anyways, so step 3, which was justification under section 1. Now, again, for those who are reading through the IRACs, just write exactly what it's written. And for those who don't have it, I'll just read out and give you an example. So you write now, moving on to the next step, we have to see if the law is justified under section 1. And for this, the burden shifts on the legislature / parliament / government, and you don't have to write slashes in the exam. You have to know which body you are actually dealing with in the exam. So you have to write the burden shifts on the dash, which is either legislature, parliament, government, to justify the violation of charter rights. Then you write the rule. You write section 1 of the charter provides as follows, and you write the exact section 1's rule in the paper, and then you further move on. You say, now judicial review of this step is done in 2-stage processes. Stage 1, the purpose of law must be important to the society or be designed to promote a sufficiently important objective. Then you talk about sufficiently important objective. You explain that rule. You mention the relevant case law, which is all written in the IRACs. Again, you're not now jumping back to notes for everything. Everything is in front of you because the paper is 3 hours long. The biggest enemy in this exam is your time. It will run by like anything, and you will end up, half finished, and then, go back in a cycle of rewriting the paper because of those bad learnings. Anyways, I'm telling you all of this in advance. Okay, so then you write the sufficient important objective, and then you move on to the stage 2, which is whether the limit is reasonable and that one can be one that can be demonstrably justified. Now, like I said, if let's say you were just saying, let's say, let's not, this party is, you put out a poster saying that this particular event is only for Caucasian people, or Asian people or black people or whatever, like you completely discriminate against everyone, and it's a public event, etc., etc., and somebody might come and say, this person has breached my charter right, and the government comes and arrests you. Now you are claiming a charter breach. Now, is the arrest justifiable? I don't know. This is a analysis that everyone should be doing, but and on their own. So the stage two, the proportionality test, which I was talking about, starts here, and you have to also justify that whatever the charter breach was and whatever the government action was there a charter breach? Was a charter breach? Can it be justified basis the actions? Like, proportionally, was arrest the okay thing to do, or was it too much of an action? If it's too much of an action, you can always say that, yeah, the charter breach is there, but it cannot be justified because the action was overdone, whatever. So rationally it doesn't demonstrably justify the actions of the government for the charter breach or whatever. So those are the things that you have to keep in mind, and these are the degrees, these are the things that everyone will come up with their own versions. This nobody can provide you. You will have to study through it, understand the concepts, and attempt accordingly. I think there was a question here. Is there a limitation of words? No, I don't think there is any limitation of words. If there will be, they will mention it in the questions. But trust me when I say this, you will not find enough words to write it. You will end up feeling that, can I write more? Can I write more? But don't worry about it. If for example, if they are asking you to write a 5-marker question and they put a limit of words, you'll see it. But I have never seen a limitation of words in this one. All right. Moving on. So once you're done with the proportionality test, there are 3 steps in this test: rational connection, least drastic means. Like, the charter right always should be minimally impaired. It should not be that you went ahead and arrested that person. Was there anything else that could have been done? Or they could have been a situation where they could have just cancelled the event, or they could have I don't know. There are so many things that could have been done in fictitious situations like that. And then you also, the third thing you mentioned is proportionality effect. For those who have notes, there's a error in the numbering, so please fix that manually. All right. So once you're done with writing the rules, this was your rules. This was not your application. This was your rules, and you have. And although they say IRAC, but it can always be a situation where you write the main issue, or maybe multiple issues, and then you write rule 1, rule 2, rule 3, rule 4, or how many were rules, and then you apply them together. So this can be your format. If you go ahead and start doing a issue, rule its application, rule its application, rule its application, that is also doable if there are multiple rules being discussed. But I personally feel that confuses the examiner. They should have like a structure, a flow, because yours is not the only person's paper they are going to be checking, right? They are going to go through entire a list of candidates whose exams will be there. So the clearer you write the answer for them, and the clearer they understand it, of course they will then highly likely pass you and not look at, what is this person trying to do, is this person following a format or not. All right, having said that, so when you move on to the applications, and I'm now going to read out from the IRACs a little bit. So under application, then you write the objective of the law is dash, and in the dash you can write some facts from your question, that the proposed amendment or proposed law was to safeguard the integrity of the, let's say, voting process by providing greater protection against voter frauds. Now this is a placeholder line. You can add whatever the objective of the law or the action of the government, private, public body was, and then you say that which is a sufficiently important objective in justifying the limit of the charter, or which as per the government was sufficiently, and then you have to be a little creative. You have to play around with the application here. Then you move on to the next thing, which is the law is rationally connected to the objective. If it's not, you write it other way. You say that although the law is not rationally connective. So these are the kind of examples I've written down in the IRACs, that this is where you need to write this language. You need to cover all 4 points. This could be directly what I've written, or it could be a reverse application where you are saying that the object of the law was this, but it's not rationally connected, and the law is not impairing or impairing minimally, and then you are talking about the disproportionality and the severe effect. And if you look at these 4 application points that I've talked about, these are actually flowing from your previous rules. So you've written down the rule, you've explained it, and then you have done an application of that rule. You have spoken about sufficient important objective. You are speaking about rational connection with the objective. You're speaking about minimum impairment with the actions, and you're speaking about disproportionality. So you are actually applying the rules that you spoke about just a step before. So in the examiner's mind, they are looking at, okay, this person has correctly pointed out the issue. They know what the issue is. Then they move on to seeing what the rules were. Okay, this person has correctly explained the rules with the relevant case laws, and now this person is doing an application and is convinced by the actions or is going against the actions. Is completely your choice. And of course, as long as you can justify it with your application, it's fine. You can't, of course, go ahead and say, no, morally I feel like this should not be done. For example, there are highly likely chances that there may be questions coming in from the whole fiasco happening of Khalistanis, etc., etc. They might not specify their names, the group's names, but they might give you a fictitious name and ask you a question like that. Now, if, let's say, hypothetically, some people are pro, some people are against. A pro person might go ahead and say, no, I want to justify it no matter what. Please don't do that. Do what you can explain. This is nobody's checking your views or questions or anything here. Do what you can explain, as long as the facts and the rules can work together and the application makes sense, which the examiner will read and say, yeah, this person has understood the law and applied it properly. Your work is done here. 80% of your work is done here. Once you have given the application, that is when you move on to the conclusion of the answer, where you say the charter right under so and so section, which whatever the law was, has been infringed or has not been infringed, but the law is not justified under section 1. So there could be 4 possibilities: has been breached, not justified; has been breached, justified; has not been breached, 3 only, has not been breached at all. So there are 3 possible situations that may come out. You might write them down, and your charter question is done. There is extension to the charter question as well, which I wrote for safety reasons. I don't see a lot of people writing it, but which is remedies. So there may be a question where they directly ask you what are the remedies if the charter right has been breached. There may be a case where they don't ask you. I kept the remedies IRAC with me, thinking that if I have extra time in the paper, I will write it anyways. Just give examiner extra input on I have more information that that you're asking. So I just went ahead and wrote it. And for remedies, there are 2 sections, which is 24 and 52, and both of them are, again, the rules are written in the IRAC that I provide. And if for whoever is studying with your own, just write these sections down and see if you can create your own IRACs in case you are doing it on your own. So that is what comes from the remedies. Effectively, it means that if your charter right has been infringed, what are the remedies that you can claim? There are 2 kinds of remedies, and that's it. Now, moving ahead, the next kind of question that might come, which would be less, which will have less weight in the exam, is the pith and substance analysis, which is division of power, also known as division of power. In Canada, there are 2 legislative powers, which is the provincial power and the federal power. So everyone has their own, own powers over certain, actions, certain jurisdictions, certain laws that they can create, not create. And this is a very, controversial thing always. A lot of issues come out that this power was supposed to be with the federal government, this power was not supposed to be with them, etc., etc. And a lot of time, federal government overshadows the power of the provinces and creates a law, and provinces are always challenging it. So these are the kinds of issues that always come. So this kind of a question is solved through a pith and substance analysis. Pith and substance analysis is a common law, analysis flowing from a case law, and it first came out in Montegeller and Canadian Western Bank case, and that has been no legislative body has made a law out of this. It's still a common law rule, so that's what you have to also apply in the exam. Now, if a question like this comes where you're being asked that which body has the power, is it the federal power government or is the provincial government, then you have to do a pith and substance or a division of power answer. You start again, and for those who have the notes, you are looking at page number 147 now. We look at the issue from the question, that nobody can give you the IRAC for that, and then you move on to the rule. and you just simply close your, of course, open your eyes, but close your mind and start writing it down. The rule is exactly here, which is the two-part pith and substance analysis, in bracket you write the case laws, determines the essential character of the law that thereafter assigns the matter to one of the heads of the legislative power. To determine pith and substance, two aspects of the law must be examined. Then you write both aspects. To determine the purpose, the court can look at preamble, the intention of the legislature, the legislative body that drafted the statute, the mischief that the law is trying to correct, and so on and so forth. So you can see the entire rule is written down on what is the pith and substance analysis and why it was made and what is the purpose of it, and what are we looking at when we are doing a pith and substance analysis. Once you've written down the rule, that is when you move on to the application, and in the application you start with the based on the you bring the facts of the case here. It appears that the purpose of the law or rule or whatever action is to do XYZ. The legal effects of the action are dash, whatever is, have to take this input from the question, and the practical effects are what is. So basically the purpose of the law may be, let's say hypothetically, there was a case law like this, and I'll give that example only. Building aerodromes falls under the power of the federal government, but there was a provincial law that came in, and they said that okay, well, you are allowed to build or not allowed to build an aerodrome on your field in a particular area. So they built an aerodrome, and then the federal government came and said, what are you doing? You were not allowed to do it. So in this situation, the pith and substance analysis will go in a situation like, okay, based on the facts of this case, it appears that the purpose of the law was to control the the air activities of planes, but the provinces did not have a power to it, because they can only limit the activity in their region, and if there's a plane flying in a different province, it'll be a breach of whatever. So it's all hypothetical. This is not the actual case law. And then when you write the law was made to do this, but practically the law is doing this, or those kind of examples are written down, and then you move on to the next step. Again, you're looking at the IRAC now. The next step, according to the court in Citizen versus Parsons, is to look at the potential relevant heads of legislative power to see which legislative power this statute could be validly classified under. Then you classify that particular law or action of the government under a particular legislative body, and then further, and you keep on writing the whole rules here you're talking about, and then in this you have to justify there are various powers that the government have. There is POG analysis, there is national concern branch, there is emergency branch, and so on and so forth. So you have to do each branch's analysis as well in this question, and all of it is written here in the IRACs. It's written here. You just write it down. If you want, of course, add anything you can, but don't remove anything. Write it down, then you come to your conclusion. You write your conclusion that according to so and so, like for example, let's say there was a provincial action, but the federal government came and they made a law, and they made it mandatory for all the provinces to follow, and they justified it under, let's say, a national concern branch, that there was a concern nationally. Let's say during COVID, a lot of overlap happened where the federal government just simply came and said, this is the new rule that you have to follow. For example, vaccine mandate, lockdowns, or whatever. There were so many work from home rules, regulations, etc., and certain powers should have been by the federal or the provincial government. But if provinces started enacting those rules, every province will have a different way of approaching towards solving a concern. But if the national government, the federal government, comes and creates a rule, and they say it's under so and so power we are, and that so and so power would be national concern branch, so it can be justified because it was required nationally for in an emergency situation. In that case it's temporary, but they can justify it, and you can say, although the power was under the provincial whatever, because you have done the analysis, it, and then you say, but because of the gap, the POG power or the national concern branch or whatever, you can the federal government, this thing, can enact law, and their law will be valid temporarily for 5 years, but it will be. So this is a kind of a division of power question that you might face. If any questions, please just write it in the comment and I'll answer in between. Then you have the third kind of question that may come, which is constitutional amendments. Constitutional amendments has been given as a separate part in your syllabus. I haven't Actually, I wrote a constitutional amendment answer, yes, but it's not like a very heavy weight in your paper. But do study it. You should not leave anything for this exam. Study everything. Uh, Constitutional amendments are under certain sections. There are 38. Sorry, there are 5 sections, which is 38, 41, 43, 44, 45. And every kind of amendment under every section is for a different kind of situation. So there are amendments which are very serious, which is amending the constitution itself, or they are amendments which are of less grave seriousness, and which with regards to, let's say, only a province, or maybe impacting only certain I don't know, certain actions. I don't know. So these are the constitutional amendment rules that are also provided in the IRACs. These are for constitutional amendments. They are just rules. I haven't given the whole IRAC of issue, rule, application, conclusion, because there is no way nobody can create a IRAC for this, because the question will be completely creative. We don't know yet. Neha's question has come. Is there a question bank of repeated questions of the past years? Any particular patterns of questions frequently asked? I would urge you not to do this, because I have faced this issue with the LSO, and NCA also tells you not to write questions down anywhere. Once you finish the paper, they will ask you to tear apart any notes that you have written. And I've seen the LSO bar exam get completely cancelled, and some people's previous results were taken under consideration for cancelling them as well. So there was, I won't name the name of the examiner, but there was an examiner who was discussing these previous questions by collecting them from students, and they took like a very serious action against everyone. So please do not use these questions from previous bank. If you are using it, don't tell anyone. All right, so moving on, we have 15 minutes left in the call, so let's just wrap it up quickly. Once this was for your the constitutional amendment. So rules are written here in the IRAC. Okay, these are, if let's say it's an ordinary legislation, this is the section that applies. If it's, let's say, only for provincial government, whatever, this is the kind of a rule that applies, etc., etc. Now, the last kind of question that might come in the paper is for Aboriginal, and this is very important. This is one question definitely is going to come from it, and it could be for Aboriginal rights or titles or both. In this kind of a structure, you start out with giving a bit of a history and the relevant sections under which they have the powers, which is section 35 and 25. It is written in the IRACs. You start out with a common paragraph which applies to both rights and titles, or both together as well, which is in 1968 Canada was formed and new constitution was formed, and it gave rise to section 91 subsection 24, which says federal government has exclusive authority to deal with Aboriginal affairs. But this section wasn't really helpful for Aboriginals in 1982 when the constitution was revised. It gave right to charter rights under 35 and 25. Section 35 deals with Aboriginals, and then you explain what is 35, what is 25. It's written in the IRACs, and when you explain this, the examiner knows, okay, this person knows where the charter rights are flowing from, and what Aboriginal rights are flowing from, and what is the Aboriginal title, where the Aboriginal title is flowing from. And then you simply look at they simply look at the rule. Okay, this person has explained properly, and move on. And before this, of course, sorry, my bad, I missed it again. Before this, you have to pick out the issue. The first thing you have to do for any question is, what is the issue? You have to nail the issue down to the properly, so that examiner knows, okay, this person knows what the question was about. They will give you random facts to distract you from the main issue, but once you are done with the reading of the entire question is when you will know what is the exact issue. There may be a case where the issue is mentioned in the first line, and the rest of the question is completely BS, or it could be mentioned in the last paragraph and the rest of the paragraph is completely there to distract you. All right. So again, Aboriginal rights. Then you in the IRAC, you can see Aboriginal right can be proved by the test laid down in R versus Vanderpeet, and things like this. The lines like this clearly tell the examiner that I know my stuff, and I don't need to get into the notes right now and open where is the test laid down of Aboriginal right, which paragraph does it mention, and what is the thing that I write in the paper. Because if I start doing that, I will waste so much time that I will miss out the exam. And I guess Out of the people who've written exams here, it's Vidya and Neha who have written papers, right? Previously.
Sorry?
Neha,
Sorry, Papa?
Neha, you have attempted an
Sorry.
exam before,
Okay.
right?
No, 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 no.
No, it's your first one. Okay. So only Vidya is here who
Yeah.
has attempted a paper before. I'm not sure about Gursimran. But Vidya, correct me if I'm wrong. Is time your not biggest enemy in the paper?
Yes, it is.
And when you have these kind of answer structures or hierarchies right in front of you, they will be your best friends in the paper. You will love them and you will just finish the paper. And I have never thrown my hierarchies away. I still have them back at home in India because I had to prepare them with my own hands. So these hierarchies will help you have your rules and your meat, if I have to call it so, literally in front of you, and you just type it down. Again, so moving on, in case of Aboriginal rights, you write things like an Aboriginal right can be proved by the test laid down in R versus Van der Peet. In assessing a claim to an Aboriginal right, a court must first identify the nature of the right being claimed or on the order to determine whether a claim meets the test of being integral, and so on and so forth. And there are parts in the IRX that I've mentioned which says add facts. So the rule is written, and then there is a section where you have to just add facts. Then the rule is written that the claim must be based on actual practices, customs, and traditions. There must be conclusive evidence from pre-contact times about practice, customs, traditions of community, and then you add facts saying, in our case, the applicant claims that he has an Aboriginal right to, let's say, hunt game, and the question will provide you. Can you suggest particular sections topic which require thorough reading and understanding? The entire notes. The notes are summary of everything that is important. So please don't leave out anything from the notes. The whatever is not important may also be there in the notes, but they are there for your understanding because a question might come from it. So everything, and I feel like the most important things are always that are just added to the syllabus. So you can always compare a previous syllabus to the current syllabus, and you can always look at the current facts, current situation that is going out in Canada, because a lot of times new questions come in and they base them out of the real world situation. Because, for example, during COVID times, a lot of questions were coming on COVID. Right now there's a huge battle going on in Canada. I don't know, called battle, protest probably going on around Khalistan and India and all that stuff. And right now Trudeau is also being questioned about his actions on the economy. Anything from those lines can come. For constitutional law, your charter rights, your Aboriginal right, these are very straightforward things that the syllabus is asking you to read. So you cannot skip anything. Yeah. All right. Coming back. You write a thing like Aboriginal right. The claim must be based on actual practices, so and so, and then you add facts from the question. Then you move on, underline the dynamic right. You mentioned there may be an exercise in modern form of pre-contract practice, custom or tradition, and the claim should be characterized accordingly. And then you add facts, link it to that, and then you move on to exceptions, saying that okay, exceptions to the Van der Peet test are so and so. This is not applicable on Métis people or people who are children of French and whatever. So this is how you start answering Aboriginal rights question. And if it's and there is again there is sparrow test in it, which if there's an infringement, can government justify their infringement through sparrow test? This is not done through Oaks test, this is done through sparrow test. And then you write the fiduciary duty, the rule on that, and then you do an application of okay, these were the rules, now these are the facts, and this is the situation, this is the answer, and I think Aboriginal rights are justified or not justified or whatever. So breach of Aboriginal rights is justified or not justified, so on and so forth. The same applies for Aboriginal title as well. So Aboriginal title, of course, stream from a different kind of rule or case laws. In this case, it is Delgamuku versus British Columbia and Silcotin Nation versus British Columbia that are the operative cases that have established, landmark cases that have established Aboriginal titles and rules around it. So these are they will guide the rules that have to be written down. The meaningful diminution test and so on and so forth. This is what you can expect in a constitutional law paper. These are the six kind of six kind of different questions that may come. There are short questions, 5 markers, which have regularly been coming. So that is the reason why you cannot skip on a lot of questions in the paper, like, for example, there was a question in the sample paper that is written the notwithstanding clause section 33. Now you may feel like, oh, this is a very small topic that might, no, everything is important. There are 5 markers, can cover anything and everything. So anyways, there's a question here: considering present situation, visa being cancelled, etc., might infringe charter rights, still justified under charter right? No. So visa, again, so you have to look at whose charter right. I don't have a charter right in Canada right now. I'm not in Canada. If I was in Canada and I was not getting a PR, my permanent residency card, in that situation, I might look at a breach saying that, okay, but that is not a charter right. That is an administrative law question, where the administrative body, which is the IRCC, who's not processing my things as per the rules, regulations, guidelines, or whatsoever, and they're not giving me opportunity to maybe a right to hearing or whatever. That is an administrative law issue. Charter rights are such as freedom of conscience, religion, freedom of thought, belief, opinion, expression, peaceful assembly, association, your life, liberty, security, right against unreasonable search and seizure, or arbitrary detention or imprisonment. Then you have right to be informed properly. You have right of equal protection, for all races, national, ethnic, etc., etc. So these are the charter rights. This is not nothing to do with your visa situation. Visa situation issues goes completely into admin law. Any other questions, guys? I guess not. Okay, so sorry, there's one more. Charter protects only citizens and PR holder rights. Charter protects everyone in Canada. If I go to Canada as a tourist and I face a charter breach, I am protected by the charter rights. It's not just citizens and PRs, but you have to be inside their jurisdiction. All right. So this was the kind of a prelude to what I wanted to give for people who are preparing for the constitutional law exam. So you know exactly what you should be studying when you are in your notes, books, wherever you're studying from. This is important because a lot of people study everything and by the end they realize they should have studied in a different manner. So this is the only thing that I got from India, because I am still working on PR material. This is my model code. Let me just turn off the filter so you guys can see. Yeah, you have to highlight every important section, flag them like this. Even inside the thing, you have to highlight things like, to keep notes, markers on paragraphs, so that in the paper you don't have to go through everything and you just have to look at 2 lines, 3, 4 words which tell you that this paragraph was about this thing, this paragraph is about this thing. You don't have to go or maybe underline the relevant parts like you prepare for cases in your courts. Think of it like that, because you will have very limited time and you will have to type so much. You cannot waste time on searching things. So have your IRACs ready or buy them out from someone. Have your notes ready, flagged, underlined, highlighted, everything in front of you, so you can go ahead and simply attempt it. And just to again caution you, Neha, 2021 was the year when LSO cancelled everyone's paper, and my exam was one day before. Like, I was writing the exam, let's say tomorrow, and one day before we get a notification that all papers have been cancelled. There were about 100 kids who were studying from that particular teachers, whose papers were also called back and they were analyzed again. Some of them had to rewrite. So there's a big issue in Canada. And these guys, and when you study professional responsibility, you will also see that they emphasize on so many times on character, good character. And even in that case, that's the reason why they have asked us to provide a good character certificate from our bars, so that there are no actions against us, etc., and we have not done anything illegal. Of course, in places like India, those things are very grey and no actions are ever taken if we ever do things like this. But Canada is really serious about it. So there are people who are keeping an eye out on people who are sharing notes, or people who are discussing previous questions, people who are jealous, people who are not able to pass, and they go ahead and make complaints. Because this was a situation, real life situation, where somebody anonymously complained to LSO that there's a huge group of people, about 100 people, who have access to previous questions, and because of this particular examiner, and they cancelled all papers. Everything was cancelled. So please do not do this publicly. Do not openly go and share stuff and talk to people about previous questions, etc., etc. That's a very risky water. If you want to practice in Canada, you need to practice, you need to go there with a complete good standing and maintain a good standing. And when you study PR, you will realize there are so many things that are supposed to be done to maintain a good standing. Having said that, oh, Vidya, please go ahead.
Yeah, so as you mentioned, if there is any tips you can add. So adding one more tip that NCA sends you a mail, I think 2 weeks ago, before the exam for a test trial of the exam. So they'll even though they'll give you the sample paper which is already provided in the NCA website, but it is a very good practice to take that exam and test your how you will be doing in the exam. That 3 hours is there, whether that is enough for you to type your IRACs, and regarding like how you will act under pressure and technical things, nobody teaches us usually. So all those things you can actually try the test prep. That it's very helpful.
Thank you so much for your
Thanks,
input.
Adela. That was
Thank you so
helpful.
much. Thank you, everyone. Thank you, Vidya, for your input, and I'll see you all in the group. The call is about to end. It's got to drop anytime now.